Hello, everybody. It's Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. This is going to be a little bit of a longer video than you're used to. I think I'm pretty much done shooting short videos. We're going to be going into deeper dives, going into sort of complex areas of law, trying to make them as simple as possible. And in this video, we're going to talk about the 4 easiest ways to get a green card to the United States. Of course, it's not easy for anyone to get lawful permanent residence in the United States, but I made a slide presentation and I'm going to go through that with you in the hopes of trying to educate you and letting you know how, if you want to come to the United States and stay in the United States, you might be able to do that. So let's get right to it. All right. So these are the 4 ways to get a green card in the United States. One is through your family. One is through asylum. One is through something called the diversity visa lottery, and one is through employment. First, let's talk about what is lawful permanent resident status. So LPR, lawful permanent resident status, means that you're allowed to reside in the United States, to stay in the United States, to live in the United States, to work in the United States. And you can, once you achieve LPR status, you can stay in that status for the rest of your life if you want, or you can apply for citizenship. So LPRs can apply for citizenship 5 years after receiving their green card. Green card is the name of the card, or the informal name of the card, that you get when you receive lawful permanent resident status. And you can apply after 5 years for citizenship. If you're married to a U.S. citizen, then you can apply after 3 years. So lawful permanent resident is a great status to have. It's an immigrant status. It means you're allowed to stay here. It's not a non-immigrant visa or status, and which is one where you're going to have to leave. So when we think about adjustment of status, so we're adjusting our status, we need to understand a pretty important concept in U.S. immigration law, and that is the difference between immigrant visas and non-immigrant visas. So non-immigrant visas are visas that someone comes to the United States temporarily, and an immigrant visa is where they've planted their flag in the ground. They've said, I want to stay in the United States. I want to be on a path to U.S. citizenship. I want to be a lawful permanent resident. So when you're in the United States and you're in non-immigrant status, you would then adjust your status, and they call it adjustment of status, from that of a non-immigrant to that of a lawful permanent resident or immigrant. Not just anyone can adjust their status in the United States. You can't just say, ooh, I want to stay in the United States. I want to be here. I really like it here. I want to adjust my status. That's not really how it works. There's 4 main ways to adjust status, and we're going to go over each of those in today's video. One thing that's important to keep in mind, that in most instances, not all, but in most instances, you need to be in valid immigration status in order to adjust your status. That is, if you have fallen out of status, or if you entered without any status, it's going to be very difficult for you to adjust your status. There are certain ways in deportation court and through asylum to get valid status. But for the most part, if you want to adjust your status to that of lawful permanent resident, you need to have valid status at the time that you apply. So that is, if you're in valid status when you apply for adjustment, you're going to have a much better chance of getting a green card, of getting lawful permanent resident status than if you weren't in valid status. So the one exception there too would be if you marry a U.S. citizen, and we're going to talk about all that. All right, so there are sort of 3 main types of people who are in the United States out of status. There are those who entered without inspection. There are those who overstayed a visa. That is, they had a non-immigrant visa to come to the United States and they overstayed. And then there's the pending extension or asylum. So this is people who came on a visit perhaps, or a student, they've sought some kind of an extension, or they've applied for asylum. And there are different protections and different paths towards lawful permanent resident status for these people who are out of status, right? So there's a different path for people who enter without inspection versus those who overstay, versus those who just have a long pending extension or asylum request. And we'll talk about those. All right, so the other thing to keep in mind is that people get their green card in one of 2 ways. They could get it after receiving an immigrant visa overseas at a U.S. consulate and arriving in the United States, or they could get it through the adjustment of status process. The adjustment of status process, like I said, is when you change from a non-immigrant status to immigrant status. If you come on an immigrant visa, either through employment or through family or through the diversity visa, you would receive an immigrant visa to the United States, and then if you do the final paperwork and pay what's called your Ellis fee, you should get a green card delivered to you in the mail. Once you get that immigrant visa, that's proof of your lawful permanent resident status, and then the green card is sort of the formal proof of that. So people get their green cards in one of two ways, either based on consular processing or through adjustment of status. All right. So when we talk about adjustment of status, we're generally talking about an I-130 or an I-140 petition. That serves as the underlying basis of the immigrant visa. There are a certain number of visas available every year, except for immediate relatives of U.S. citizens, and we're going to talk about that. But basically, there has to be an underlying application or petition, which then supports the application for adjustment of status. So in most instances, you can't file a standalone I-45. There needs to have been something else, perhaps a K-1 visa, which is an I-129F petition, which is for fiancés, or usually an I-130 or an I-140 petition. All right, so first we're going to start off with family-based green cards. Family-based green cards. All right, so I want to go through who can be sponsored and who's eligible for sponsoring. So the only people who can sponsor family members to come to the United States are U.S. citizens and green card holders. So first we're going to talk about U.S. citizens. A U.S. citizen can sponsor their spouse, their parent, their child, or their brother or sister. So one of the benefits of being a U.S. citizen is that you can sponsor people in greater categories and with greater priority than you can when you're a lawful permanent resident. So U.S. citizens can sponsor their husband or their wife, their mom or their dad, their son or their daughter, or their brother or sister. Now, within that, there's certain categories of people that are called immediate relatives, IR, immediate relatives of a U.S. citizen. These would be the spouses of a U.S. citizen, the parents of a U.S. citizen, and the children if they are under 21. Those are immediate relatives of the United States. The great thing about being an immediate relative is you are given greater priority, and you also, there are an unlimited number of those visas available. So there are caps on other categories, but for these three categories, the spouses of a U.S. citizen, the mom or dad of a U.S. citizen, and the child, if they're under 21, of a U.S. citizen, those are all immediate relatives, and we're going to talk about the benefits of that. Like I said, there's no cap. There's an unlimited number of visas. So as long as you go through the process of adjustment or the process of an immigrant visa, there's no artificial delay of that. Everything else, Congress has capped it, and therefore there are delays that we'll talk about. One of the other benefits of being married to a U.S. citizen or the immediate relative of a U.S. citizen is that any overstay is forgiven. So if you entered on a visit visa years ago and marry a U.S. citizen, or if your U.S. citizen child turns 21, or if your child gets their citizenship and you're here and you entered a long time ago and didn't leave, that overstay would be forgiven. That's not necessarily true if you entered without inspection. There's more to it than that with people that entered without inspection. That is people that snuck into the United States. Another benefit is for unauthorized work, that is also forgiven. And the last benefit is that you're allowed to file what's called a one-step. You can file the I-130, which is the petition for alien relative that the U.S. citizen files for the foreign national, and the 485 together. You can file them simultaneously at the same time, and you don't have to wait for the I-130 to be approved and for a priority date to become current before you file the I-485. All right, now let's talk about the relatives of U.S. citizens who are not immediate relatives, and that would be the adult children and the siblings of U.S. citizens. For them, there's a cap and there's a long backlog, and they don't get those protections like getting unlawful presence waived or unauthorized work waived. They don't have those protections like an immediate relative does. Now, let's talk about who a lawful permanent resident can sponsor. They can only sponsor their spouse or their child. That's it. A lawful permanent resident can't sponsor a brother or sister, can't sponsor a parent, only a spouse or a child. Now, sometimes a lawful permanent resident might be married to a U.S. citizen, and they might get the U.S. citizen to sponsor like that person's stepchild. But they generally, a lawful permanent resident can only sponsor their spouse or their child. And the negatives for LPR beneficiaries, again, there's that cap, so there's a limited number of visas. Overstays are not forgiven. and unauthorized work is not forgiven. Now let's talk about preference categories. So Congress limits each category of immigrants. Congress has limited all these categories of immigrants, the ones that we just talked about. There are caps on those, and whenever you have a cap, you have a delay and a wait. All right, so the F1 preference category, that's different than the F1 visa. That F1 visa is a non-immigrant visa for students. This is the F1 preference category, which is part of the family-based visa scheme. These are the unmarried sons and daughters of U.S. citizens, the ones who are over 21. Therefore, they're not immediate relatives. The current wait for them is 7 years or more to 23 years. So certain countries, usually Mexico, China, India, they have longer waits than everybody else. And so if you want to sponsor your unmarried son or daughter, that can be anywhere from 7-year wait to a 23-year wait. They're working on cases from long ago, more than 2 decades ago. The next category is the F2A preference category. These are the spouses and children under the age of 21 of lawful permanent residents. Currently, there's no extra wait. This is a current category at the moment that we make this video. Now, for most of my career as an immigration lawyer, these were not current and there was a delay, which would mean that you have to file the I-130 and then wait for it to get approved. And then once the priority date becomes current, you could file for adjustment. Right now, that's current. That's true also for overseas cases. They can go ahead and start processing their immigrant visas to come to the United States and get their green cards. But that's sort of an unusual time that we're in. That's not always like that. Sometimes there's a delay. The unmarried sons and daughters of LPRs over 21, that wait ranges from 6 years to over 22 years, if you can believe that. So if the child is over 21, right now it's a 6-year wait. I remember when it was a 9-year wait. So that's actually gotten a little bit better. And that's for the unmarried sons and daughters of green card holders who are over the age of 21. Then we have the F3 preference category. These are the married sons and daughters of U.S. citizens. That's a current wait of 13 to 24 years or more. So that's a really long wait. But then the longest wait of all, well, that's the longest wait of all. And the second longest wait of all are the brothers and sisters of U.S. citizens. Their wait is 14 to 22 years. So I know it sounds like a very long time, but every year we handle cases for people that were smart enough to file these cases long ago. And now their brother or sister and their family are coming to the United States. All right, now, if the foreign national is an immediate relative and is in the United States, then they can file, like I said, the I-130 and the I-45 together. That's a one step. They file them all in one, and you'll generally have the interview for the I-130 and the 45 together when the case is done processing. You're also going to need to file the I-130A, which is a biographical form about the beneficiary, the I-765, which is for work authorization, the I-131, which is advanced parole, and the I-864, the affidavit of support. If the foreign national is outside the United States, you would file the I-130 alone. And so you would file that, and then you would deal with consular processing later. Yeah, you'd get, once the I-130 is approved by USCIS, the case is transferred to the National Visa Center for later consular processing. So that's a slow process. And again, you're dealing with the two agencies, USCIS and the Department of State. So you have to get USCIS to conclude that the relationship is a valid one. And then the State Department does the processing and the final decision in whether or not to get the visa. All right. When you file your I-130 petition and your 485, you get a priority date. This is your place in line. It's the day that USCIS issued a receipt on your case. So if your priority date is January 5th, 2022, someone who filed on January 4th, 2022, they're in line ahead of you. Someone who filed on the 6th, they are behind you in line. So that's sort of how that works. That's why your priority date is really important, because your priority date will help you in figuring out when you can have your case processed at the embassy. For the most part, you can't file for adjustment until your priority date is current. Of course, this doesn't apply to immediate relatives, but if your priority date isn't current, you're basically in a holding pattern. And the way that you check to see if your priority date is current is your monthly visa bulletin. So every month, the State Department issues the visa bulletin. So if you just Google the month and year that you're in, plus the word visa and the word bulletin, you'll get information and you'll get data on which cases are being approved and what priority dates are current. So when you're talking about non-immediate relative cases, you need to make sure that you always keep your address current with whichever agency your case is. So if you're still pending at USCIS and you move, you want to make sure you notify them of the address change. And if your case is at the State Department, same thing. And then, of course, you always want to make sure that you check in at least once a year so that no one can say that you abandoned your petition. All right, so that's basically how family cases work. I hope that makes sense. I hope you got a lot out of that. Let's turn our attention to asylum. So asylum is the second main way that people get on a path towards lawful permanent resident status. In order to win asylum, you have to show that you have a well-founded fear of persecution back in your home country. You think something bad's going to happen to you, that you're going to be persecuted. This is a very high standard. They don't give out asylum very easily, and they don't give it out as easily now as they used to. A well-founded fear means that you have a credible or a believable fear. That is, can you convince an asylum officer that this fear is real? Is it based on facts? Is it based on specific threats of harm? It can't be sort of a guess or a feeling. You have to convince them that you're going to suffer this persecution. And what is the best way to show persecution? The best way to show future persecution is by showing past persecution. So obviously, no one has a time machine and can go in the future. But if you've been persecuted back in your home country in the past, that makes it more likely that you're going to be threatened in the future with future persecution. So that's definitely one thing you need to keep in mind when you're putting your asylum case together. Now, your persecution can't be for any old reason. It has to be based on one of five things. It has to either be based on your race, or your religion, or your nationality, or your political opinion. And then there's a catch-all called membership in a particular social group. So I think most people understand about race. They understand about religion. So for instance, if you're a Sunni Muslim and you fear going back to Iraq because the Shia militias or the Shia government is going to torture you, that would be the basis of it. Nationality, if you're from the Ukraine and you feel that if you get sent back to Russia, you're going to be sent to war or tortured. Your political opinion, so if you've been an outspoken critic of your country's government, or membership in a particular social group. So we'll talk about that right now. A particular social group means that there are common traits about you and other people, that it's sort of a definable group, like based on their gender or their color or their kin, their family, like their tribe, or shared past experiences. So, like for instance, gay people who don't want to go back to Saudi Arabia, or people who Guatemalan women who are beaten by their husbands who the government won't protect. That would be, in theory, a valid particular social group, a PSG. In order to file for asylum, you have to be physically present in the United States, and anyone can apply for asylum even if they entered without inspection. So asylum is a way, if you are in the United States, that you want to try to get a green card and get perhaps an illegal entry forgiven, or to get on a path to a green card, you can apply for asylum. So anyone can apply for asylum. People on a non-immigrant visa can apply for asylum. And then the important thing to keep in mind is that there's what's called affirmative asylum and defensive asylum. So affirmative asylum means I'm here in the United States. I may be in status, I may be out of status. I'm going to make a formal application for asylum. That will be filed, and that will be pending, and that will be eventually adjudicated by an asylum officer. Defensive asylum is when you're put into removal, and if you fear persecution, you can raise asylum as a defense to deportation. We're going to talk about that. The application that you file is called an I-589, and the form is very detailed. You want to put in as much detail and explanation as you can. You also want to have a strong personal statement. When we handle an asylum case, that's what we spend the most amount of time on, is building our client's personal statement so that we can explain to the officer, even before they meet us, why we fear persecution, why we fear going back to our home country. And then, of course, the country conditions. So we want to have objective proof and evidence from other sources, NGOs, government, the US government, about the conditions for my kind of application, for my kind of protected class, for what I'm trying to demonstrate. We want to submit extensive evidence that shows that it's not just me saying that, it's other people. When you apply for asylum, you're generally going to apply for withholding of removal and protection under CAT, the Convention Against Torture. It's all done on that I-589. Asylum is sort of the best here because asylum is the only one of these three that gets you on a path to a green card. But sometimes people have a problem with their asylum case, and all that they get is withholding of removal, which basically means you've been ordered deported, but the judge is not going to send you back home. But he or she's not going to give you a path to a green card or any long-term status. Same with CAT protection, Convention Against Torture. We talked about the asylum office interview. That's supposed to be non-confrontational. And one thing to keep in mind there is that very quickly the officer is going to want to get to, why do you deserve asylum? What about your case? They don't want to just hear generalities about how things suck in South Sudan. They want to know why, if you go back to South Sudan, why are bad things going to happen to you? They want to know who's going to do it to you. They want to know how you know this. If USCIS approves the asylum case, they issue you an approval notice and an I-94, and then you can obtain work authorization. At this point, you're called an asylee. And then 1 year later, the asylee can apply for lawful permanent resident status. So that's how an asylee would get lawful permanent resident status. If USCIS denies the asylum case and you're out of status, the case is referred to the immigration court for possible deportation. If you're still in valid status, then you can continue on as you were. But if not, and you get sent to the deportation court, then you can raise asylum as a defense to deportation. The immigration judge, then at that point, when you're in immigration court at the EOIR, the Executive Office for Immigration Review, that immigration judge worked for the Department of Justice. Under Donald Trump, they were told for 4 years straight to deport as many people as possible. There's also a government attorney there trying to poke holes in your claim. These cases, it's really ironic. They take forever, and then you only get a half hour or 45 minutes to basically make your claim to stay in the United States. And at this point, it's much more confrontational than at the old asylum office. If the judge approves the asylum grant, and some judges approve 2 or 3 or 4% of their cases, some judges approve 40%. It really depends on the judge. They too would issue a new I-90. You get a new I-94 from USCIS, and then you can apply for a green card 1 year later. One thing to keep in mind about asylum is that you generally have to apply within 1 year of arrival. If you've gone back and forth to your home country a lot, that hurts your case because that shows that you weren't really that scared, at least in their mind. One of the exceptions would be that if things changed in your home country, that then made you fear asylum. So for instance, if you were here in the United States for years leading up to the Russian invasion of Ukraine in February 2022, if you'd been here for a while and never applied for asylum, and then when Russia invaded Ukraine, then that gave you a new reason to fear going back home, then that would be a way to get around the 1 year rule. And if you've maintained your status, that would be another reason why the adjudicator could decide. It's not a had to decide, but it could decide to let you pass for not having filed within 1 year. We talked about that. The spouse and children under 21 can be included in your asylum application as derivatives. So sometimes you want to think about who has the stronger case. Is it me or my spouse? And then any children can be included on your asylum application. One thing to keep in mind is if the judge concludes your asylum case is frivolous or fake, you can be denied any immigration benefit in the future. So that would be obviously a problem for you. That would sort of strip you from ever getting an immigration benefit. And then I just want to be clear about refugees. Refugees are people outside the United States who fear going back to their home country. They're usually in a refugee camp. They've been a victim of war, and they go through a multi-year process through the United Nations High Commission on Refugees, and they might get placed in the United States. If they get to come, they too can get a green card 1 year later. So refugees are different from asylees in that they're outside the United States. Asylees are here in the United States. So that'll do it for asylum. And now we're going to talk about the diversity visa, So the DV allows people from underrepresented countries to adjust their status to lawful permanent resident or to obtain an immigrant visa. So this is its own basis for lawful permanent resident status, its own basis for an immigrant visa. In 2019 and 2020, around 14 million people applied. Now that number dropped in 2021 because Donald Trump basically stopped processing those. He had the State Department stop processing those. But basically 14 million, 13 million, 12 million, around there is what usually applies. Now they only have 55,000 of these, so you have a less than 5% chance, but I know that sounds like a long shot, but every year our immigration office actually handles a few of these. Now, right now, because the embassies are really not processing these, they're being sued, and for some reason they're fighting those lawsuits, it's easier to get adjustment based on the diversity visa. If you're in the United States and if you're in valid status and you win the diversity visa, you can adjust your status all right here in the United States. And those cases are more popular right now and more successful than immigrant visas. The way it works is you would apply in October. So let's say you apply in October of 2022. The lottery selection is in May of 2023, and then you would start processing in October of 2023. So you have 1 year to get that whole process taken care of. And when you win the diversity visa, you're given a line number, sort of like a priority date. Your number could be 1, your number could be 3,000. And again, you're looking at the visa bulletin every month to see if it's early enough for you to apply for your immigrant visa or for your adjustment. You have that 1 year to get it completed. If you don't get it completed in that year, it's as if you were never selected and you sort of never won. All right, and the last way to get a green card in the United States is through employment. So this is where generally where an employer is sponsoring you for a green card. So this will be the fourth and final category that we tackle. Immigrants are generally prohibited from working in the United States unless authorized by law. That's an important thing to keep in mind. And most people, when they're here on a non-immigrant visa, they're not allowed to work unless the law allows. For instance, an F1 student can work 20 hours a week on campus, and J1s and F1s sometimes can get permission to do a little bit of work. Some derivatives of non-immigrant employment-based visas also can get work authorization. The H-1B is the main visa that most non-immigrants get to work in the United States. That's a non-immigrant visa, the H-1B visa. They're hard to get because demand is high, so they get many more people applying for them. So every year there's a lottery. And of course, an H-1B visa is only temporary. It's good for 3 years, and then you can renew it for a total of up to 6 years. And the law does allow foreign workers to adjust their status through the employer sponsorship. They would also allow it through the immigrant visa process at the consulate. Immigrants can obtain LPR status through work. And like I said, it's either by adjustment or immigrant visas. And there are 3 main employment-based cases that we see a lot of: the EB1, the EB2, and the EB3. The EB1 category is for priority workers, people of extraordinary ability, outstanding professors and researchers, multinational executives. So these are sort of high-level, very highly compensated people that the United States is willing to give green cards to. The EB2 categories is for people with advanced degrees, so a master's or a PhD, or people of exceptional ability. And then EB3 category has 3 parts to it: skilled workers, professionals, and unskilled workers. Most employment visa cases require a prevailing wage determination, and you have to go through the PERM process. So most employers don't like the PERM process. It's very tedious. It's very slow. It takes about a year to get a prevailing wage. So you have to demonstrate what the prevailing wage is. The Department of Labor will determine based on the information you give them about the job selection, the job that you're trying to fill, and they will tell you what the wage has to be. So employers don't like that either. And then they have to go through the recruiting process. They have to publish it in certain newspapers and other places. And then they have to be willing and able to demonstrate that there aren't any Americans that can do the job. So the PERM process is designed to protect the American workers. Of course, Congress cares about the American workers more than they do immigrant workers. And so anyone who wants to sponsor someone for an employment-based green card is going to have to be ready to prove upon request that there aren't any qualified U.S. citizens or green card holders who can do that job. The EB4 category is sort of a catch-all. There's special immigrant visas for religious workers, for Afghan and Iraqi translators, for people that are affected by VAWA, the EB4 category. And then the EB5 category is the investor program, and that's sort of beyond the scope of this video, but that's sort of where people can invest in the United States and get an investor visa. On the employment side, there are some long backlogs, like some family visa categories that we talked about earlier. And this is especially true for people from China and then India. People have waits of up to a decade. All right, so that'll do it for the presentation. That'll be everything that we wanted to share with you that goes to what it takes to get an immigrant visa or a lawful permanent resident adjustment of status in the United States. We hope you found it helpful. If you have any questions, make sure to give me a call at 314-961-8200. You can email us info@hackinglawpractice.com. Be sure to join us in our Facebook group, which is called Immigrant Home. If you like this video, we ask that you please share it out on social, that you subscribe to our YouTube channel, that you join us. We're live pretty much every day on YouTube and in our Facebook group, answering as many of your immigration law related questions as possible. We love helping people. We'd love to help you if you have any questions, but we hope this video sort of clarifies who's eligible for a green card and who is not, and that you found it helpful. If you leave us a comment down below, we'll respond, and we'd be happy to hear from you. Thanks a lot. Have a great day.